Mike Biddle, the city attorney, actually wants to make a few comments.
Good evening, commissioners, and for everybody here who doesn't know who I am, my name is Mike Biddle. I'm the city attorney for the city of Emeryville, and in that capacity I also serve as the general counsel for the redevelopment agency. I provided to you at the before the meeting started a copy of a letter dated of today's date that is addressed to the firm of Shute Mihaly Weinberger. I previously gave a copy to the court reporter, as I would like the letter to be included in the record. There are additional copies of the letter that are here. I have previously faxed a copy to Shute Mihaly this afternoon, and it was addressed specifically to Alan Garber and Robert Perlmutter. The letter provides and sets forth that the city is strongly objecting to the involvement of Shute Mihaly Weinberger in these proceedings, and in particular their representation of the East Bay Alliance for Sustainable Economy, also known as EBASE. It's the city's view that their representation of EBASE is a clear violation of the California Rules of Professional Conduct, in particular Rule 3-310, and it is a rule governing their professional responsibility as lawyers. Accordingly, the city is demanding that Shute Mihaly Weinberger refrain from further representation of EBASE in the pending proceeding before you tonight involving the proposed Pixar expansion project, as well as any other matter which is antagonistic to the city and the redevelopment agency. The city is further demanding that Shute Mihaly Weinberger affirmatively withdraw their April 8, 2004 letter and all the attachments and exhibits thereto, which is part of your packet, and we ask that they withdraw it from the administrative record in the proceedings that are before you tonight. Give you a little bit of the background of the basis of our objection. On July 12, 2001, the city of Emeryville, through the city attorney's office, retained the firm of Shute Mihaly Weinberger relative to matters involving Technichem, which is located at 4245 Hollis Street in Emeryville, and we entered into a professional services agreement of that date. Section 5A of that agreement provides that the city shall have the right to terminate the agreement for any reason by providing written notice at least 5 calendar days in advance of the termination date. There's no provision that allows Shute Mihaly to terminate the agreement. The city has never provided Shute Mihaly Weinberger any such written notice of termination. The agreement remains in effect. As we were finalizing the terms of that agreement in July of 2001, we also worked together to finalize the city's appeal, which was filed on July 6, 2001, and it was appeal filed with the Department of Toxic Substance Control relative to DTSC's decision to issue a final standardized permit to Technichem. The city's appeal has since languished with DTSC's permitting section for quite some time. And in part, the reason that it languished was that DTSC's enforcement section, 2 different sections of DTSC, that their enforcement section was pursuing litigation against Technichem for violation of a previous partial consent decree and order that DTSC and Technichem had entered into. And regardless of the fact that this matter had languished for some time, the city was and remains committed to resolving the issues with Technichem, and at that time, had DTSC rejected the city's appeal, we were prepared to move forward and appeal that decision to an appropriate court. Nevertheless, as it turned out, just recently on December 17th, 2003, DTSC and Technichem entered into a stipulated judgment that was entered in Alameda County Superior Court, which settled the enforcement action which had delayed DTSC's action on the city's appeal. The stipulated judgment that was recently entered into provided that Technichem would close its recycling facility effective December 31st, 2003, and then further undertake hazardous materials cleanup activities under DTSC's oversight. My office, with the ongoing assistance of Renee Vandergreen of Environ, an environmental consulting firm, which has, Ms. Vandergreen was retained by the city back in 2001. With her assistance, we continue to interact with DTSC relative to the cleanup activities to be undertaken by Technichem in order to ensure that there is protection of public health and safety. Additionally, we have been made aware, the city has, that Technichem now proposes to continue operating a transfer facility at that location. It is something that we, at a staff level, believe is outside the scope of their conditional use permit that was issued back in 1987. Accordingly, this saga involving Technichem is clearly far from over. And we will certainly see more of this either before the Commission or the Council in the future. Thus, the city does have a continued need for outside counsel in the Technichem matter. We have the services of Shute Mihaly and Weinberger under contract already relative to that matter. And in light of a recent Court of Appeal decision in the matter of Nightlife Partners Limited versus the City of Beverly Hills, a case which impacts the ability of a city attorney's office to both prosecute a matter as well as to advise the body hearing the matter that's being prosecuted. It necessarily requires the assistance of outside counsel. So with this matter pending on Technichem, on July 31st, 2003, the city received a Public Records Act request regarding the proposed Pixar expansion project from Shute Mihaly and Weinberger, a letter authored by Mr. Perlmutter on behalf of EBASE. The letter, in addition to requesting documents, asserted at that time that the city and agency, quote, seem intent on approving the project without adequately addressing, analyzing, or mitigating its impacts on the city's residents and the environment. Essentially, the letter is accusing the city of acting in violation of CEQA, even though the environmental review process hadn't even been begun. It's just getting underway, and nothing had been circulated for public review. This letter, we believe, is patently adverse to the interests of the city and the agency. On August 12, 2003, the city, we notified Shute Mihaly of our objection to their concurrent representation of EBASE, to which they haven't responded. Thus, thereafter on April 8, 2004, during the comment period on the initial study mitigated negative declaration, the city received a letter from Shute Mihaly and Weinberger purporting to represent EBASE on matters relating to the environmental review for this project. The letter, as you may have read, concludes that the mitigated negative declaration prepared for the proposed Pixar project is legally inadequate, that it does not provide the analysis required by CEQA, and that an EIR should be prepared. This letter is again adverse to the interests of the city and the agency. So the city again hereby renews its objection to their concurrent representation of adverse clients. With that background in mind, the city has asked Shute Mihaly and Weinberger to review the California Rules of Professional Conduct Rule 3-310, and the numerous cases interpreting the rule. The review of these cases shows that the standards have evolved for conflicts arising out of simultaneous representation of clients with potentially adverse interest, and for conflicts arising out of successive representation of clients with adverse interests. Where the representation is successive, that being when an attorney is engaged to represent the interest of a party that are adverse to a former client of the attorney's, the chief fiduciary value jeopardizes that of confidentiality. But when the potentially conflicting parties are simultaneously represented by the same attorney, the primary value at stake is the attorney's duty and the client's, in this case the city's, legitimate expectation of loyalty rather than confidentiality. There are two duties, the duty of confidentiality and the duty of loyalty, and in this city's position that in this particular instance we are dealing with both such duties. The California Supreme Court has found that where the duty of loyalty applies, it requires a per se or automatic disqualification in all but a few instances which do not apply in this instance. And the reason should be evidently clear to them. A client who learns that his or her attorney is representing an adversary in litigation, even with respect to a matter that is unrelated to the one for which they were retained, how can you expect there to sustain this level of confidence and trust in the counsel that you hired? So it is for this reason and others that the courts and ethical codes alike prohibit an attorney from simultaneously representing two client adversaries, even where the substance of the representation is unrelated. Accordingly, it is the city's position that even though the Technichem matter languished for some time, the record is clear that one, Technichem matter remains an ongoing matter of concern to the city. Two, the city has not terminated the agreement with Shute Mihaly and Weinberger. Three, Shute Mihaly and Weinberger has not, nor has it attempted to, withdraw as special counsel to the city of Emeryville. And four, there is no written consent executed by the city which would permit the conflicting representation of EBASE. Even assuming if Shute Mihaly attempted to withdraw from representation of the city on the basis that it was a long dormant matter, that the Technichem was dormant. The Supreme Court noted in the Flatt decision that so inviolate is the duty of loyalty to an existing client that even by withdrawing from the relationship, an attorney cannot evade it. So it is our position, the city's position, that we request and reaffirm our demand that Shute Mihaly and Weinberger refrain from representing EBASE in this proceeding or any other proceeding adverse to the city, and we demand that Shute Mihaly and Weinberg withdraw their comment letter of April 4th as well as all their attachments and exhibits. If they fail to comply with the request of the city wants it on the record that we are reserving our right to seek full redress of our legal and equitable rights under the agreement and as provided by law. Thank you.
Thank you, Mike.